Well, thanks everybody for joining us here today. Let me get Hayley's presentation queued up as well. And I think we're a few minutes past, so I'll dive right in. So we'll start with the introduction overviews, and then we'll pass it over to Hayley for her focus presentation on intervenor compensation, and then have some discussion around that, provide an update, particularly on the SCHIP proposed decision, and close it out. So this slide will be available, and just emphasizing that we are funded. This work is being funded by the CPUC under its Equity and Access Grant Program. I'm Josh Simmons, co-director of the Southern California Tribal Chairmen's Association Tribal Energy and Climate Collaborative. I'll turn it over to Peter for a brief introduction. Now, Stephen, you're here as well. You guys want to briefly introduce yourselves?
Sure. Stephen, do you want to introduce first, and then I can do an intro that transitions into Hayley?
I'm Stephen Moss. I also felt that earthquake in San Francisco quite sharply in my 19th century building. I'm Stephen Moss. I serve as a regulatory economist for LGSCC. I'm sorry, for the tribes and for other people as well, with a company called M-Cubed. So, Peter.
Thanks, Stephen. So I'm Peter Allen. I'm a former PUC attorney and administrative law judge. I've been helping out TECC with PUC-related stuff, including a bunch of the other trainings that we've been doing. Hopefully you've seen some of those. In 1998, I went to work for the PUC. And when I started there, an administrative law judge came up to me and greeted me and said, "Oh, I'm working on an intervenor compensation request that has hours of your time in it." He wanted to know if I was going to get the money, but no, because it was hours that I'd put in when I worked at Turn in 1994. So this was 4 years later. So this tells two things. Actually, it tells a few things. One of them is this intervenor compensation program has been around for a long time. And even in the good old days, it was not fast. It can take quite a while. Also, I think the last time I actually prepared an intervenor compensation request was probably in 1994. So we figured it might be good to have someone who has more current knowledge about doing that. And so we have Hayley Goodson here, who is with Turn. And Turn is probably one of the more consistently successful intervenors at getting intervenor compensation. And Hayley is very familiar with the Intervenor Compensation Program and how it works, and is an attorney with Turn now. And with that, I'll turn it over to Hayley, and she can add any more intro that she might need to add. So go ahead, Hayley. Thanks.
Thanks so much, Peter. Well, everyone, I'm Hayley Goodson. I've been at Turn for more than 25 years, actually. So I have participated in the Intervenor Compensation Program for a long time, and it is an honor to be here today to share with you what I've learned, my knowledge and experiences. But I want to first just clarify that I have never worked for the Commission, and nothing that I say is intended to be on behalf of the Commission. So the Commission does its own interpretation. I'll just share my experiences with you. So I want to start by saying something that Peter foreshadowed a little bit, which is that the Intervenor Compensation Program is a tremendous resource, but it's not a perfect solution to removing barriers to participation in the Commission's proceedings. There are hurdles and uncertainty at every step of the process. So my hope today is to help you understand and navigate the program requirements so that you can successfully participate in the program. But it's also possible that you may conclude that statutory changes to the program would be helpful, or that another funding approach would be a better fit. And I'm not going to get into that. I will leave those considerations to you. So next slide, please. So I usually write things with a table of contents, and so it was kind of hard for me not to do that. So what I just called it a roadmap. But what we're going to do today is I'm going to provide a brief history and purpose of the program. I'm going to give you a high-level overview of the program eligibility requirements, and then we're going to do a deeper dive into the main elements of participation in the Intervenor Compensation Program. The first is the notice of intent to claim intervenor compensation, which is required to establish preliminary eligibility. We'll talk about what that entails, and also the things that may be hurdles. Then we will talk about filing an intervenor compensation claim, which comes much later in the process, and what you need to do in order to have a compliant claim, one that meets the requirements, and also things that you should know long before you get to the place of preparing a claim, things that will help you be prepared. And finally, we'll talk about what an intervenor compensation award looks like, its timing, that sort of thing. So let's jump to the next slide. And my slides are very detailed, and I, fortunately for your sake, am not going to read them. I'm just going to touch upon some of the contents in them, but I wanted you all to have a resource to turn back to and see more information. If there are things I talk about and you want to go back to, you'll see much more in the slides themselves. Also in the slides, I often reference California law, where the Intervenor Compensation Program is housed, the Commission's own rules of practice and procedure, and the Commission's website and policies related to intervenor compensation. So you can refer back to those resources as well. So in a nutshell, the Intervenor Compensation Program has been around for more than 40 years. The Commission started it in 1981 following a change in federal law. A few years later, the California legislature codified the program, effective in 1985. And since that time, the legislatures modified the program a little bit from time to time, but the basic framework is still in place today. The Commission administers the Intervenor Compensation Program in accordance with California statutes and the Commission's own rules of practice and procedures and guidelines. So the Intervenor Compensation Program from its inception has been intended to ensure that individuals and groups that represent the interests of utility ratepayers have the financial resources to bring their concerns and interests to the Commission by participating in its proceedings. And the Commission in the late 80s explicitly recognized that it needed participation by a socioeconomically diverse, culturally diverse, and geographically dispersed public in order to best render decisions in the public interest. And so the Commission at that time modified its own regulations in order to more effectively remove barriers to participation. And so today, the way the program works at a very high level is that eligible intervenors and entities that participate in the Commission's proceedings involving electric, gas, water, and telecommunications utilities may request compensation for the reasonable costs associated with their participation if they have made a substantial contribution to a Commission decision. Now, in the next 20 minutes or so, we're going to actually work through all of those kind of buzzwords in that very succinct articulation. So let's turn to the next slide, please. All right, here are the links to the resources I'm going to be talking about, and these are just for your reference. You can go ahead. Okay, at a high level, in order to seek intervenor compensation, you have to be an official party in a proceeding. You need to file the NOI, the Notice of Intent to Claim Compensation, on time. In that notice of intent, you must demonstrate that you have customer status. You must also demonstrate that you would face significant financial hardship from participating in the Commission's proceeding without intervenor compensation. And even if you do all these things, I need you to know that eligibility for compensation in no way ensures compensation. So you do not need to be an attorney to file an NOI. Anybody can fill out the form. The commission has a form on its website, but there's a lot of information you need to provide. Fortunately, the commission is quite good about providing parties an opportunity to resubmit an amended NOI if you don't check all of the dots correctly. So we're gonna go through these things in more depth in a moment. Next slide, please. So the second step would be applying for that award of intervenor compensation. You have to have satisfied the NOI requirements, and you have to make a substantial contribution to a commission order or decision. It's not enough to just file things and participate. You actually have to link your participation to one or more outcomes that the commission adopted. And once again, you have to timely file that claim, which we'll talk about that. And then the award itself is going to be limited to compensation for costs that the commission determines are reasonable for your participation and the substantial contribution that you made. It's not necessarily all of your costs. Next slide, please. Okay, now we are going to dive into the notice of intent. And I'm going to spend quite a bit of time on this because this is really the sort of most important early hurdles to overcome to even be eligible to one day submit a claim. So there is a form, as I mentioned, on the Commission's Intervenor Compensation website, and I'm going to be referencing different parts of that form in my presentation, so you can go back later and find the things that I'm referring to. So the first thing is timeliness. The commission tends to have zero tolerance for late filed NOIs, and that's because there's a statutory deadline or statutory deadlines. And so you need to know that it's coming and be prepared for that. There are a couple of different deadlines depending on the type of the proceeding, but the most common one is that the NOI will be due 30 days after the commission holds a pre-hearing conference in a new proceeding. And so that's often within the first, let's say, 2 months of a proceeding starting. It's pretty early on, and it may be at a time when everybody's not even sure what issues the case is going to cover. But nonetheless, that is a hard and fast deadline for filing the NOI. It is also possible that issues may emerge, new issues that weren't foreseeable after the time when there was an NOI deadline. And California law allows the commission to set a different deadline when that happens. So there's kind of an off-ramp there. If things really change in the case, then there may be a new opportunity to submit an NOI. So I have a couple of tips for you about timeliness, and one of them is that if things really change and you're interested now because something new has popped up and you didn't know from the beginning that was going to happen, you can file a motion in a proceeding asking the commission to permit the filing of an NOI. You may have to prompt that opportunity, but there is a way to do it. And I also just want to say that it may make sense to file an NOI in a proceeding, even if you're not sure if you're going to be able to participate or how much, in order to preserve the opportunity for claiming intervenor compensation later. So it's sort of like reserving that chance, and it may make sense to put the work in early on so that you could benefit later. Next slide, please. So customer status, I said you have, in the NOI, you need to establish customer status and significant financial hardship. And according to the Public Utilities Code, state law, there are 3 types of eligible customers for the Intervenor Compensation Program. And I have a lot of information about those 3 types here. I'm going to just touch upon sort of some high-level things based on what I think may be most relevant to you all. So a category 1 customer is a person. It's like me. I could be a category 1 customer. I intervene. I say, I'm a utility customer. I've got some issues I'm interested in, and I think that these issues may be shared by other people. And so I file an NOI identifying myself as the customer. So I suspect that's not going to be how tribes would be participating, but I want to just let you know there is that opportunity for a single person to participate. And if you're a Category 1 customer, you demonstrate significant financial hardship by actually providing your own personal financial information, and you can ask for permission to do that confidentially from the commission, and have a confidential filing to do that. So next slide, please. Okay, a Category 2 customer it's similar to Category 1, except that it's if I find a representative to represent me. And so the representative is the customer, and they may represent just me, or they may represent a group of maybe my neighbors. We have a similar interest, but we are customers of the utility, and we've gotten together and asked someone to represent us. And so a Category 2 customer needs to identify the actual residential customers that are being represented and provide an authorization signed by at least one of those people. So that would prevent me from saying I'm a Category 2 customer and I'm representing all my neighbors, but my neighbors have no idea that I'm doing this. So that's how you demonstrate it. And similar to Category 1, a Category 2 customer needs to show significant financial hardship by providing the personal financial information for at least one of the actual customers who will be represented. Next slide, please. All right, Category 3. This is the one that I suspect is the most likely to be the right fit. And so I'm going to spend a little bit more time with this one. So a Category 3 customer is like TURN. TURN is a formally organized group authorized by its articles of incorporation or bylaws to represent the interest of residential customers, or to represent small commercial customers receiving bundled electric service from an electrical corporation. And the commission has, over many years now, allowed certain environmental groups to establish Category 3 customer status when they are authorized by their bylaws to represent residential customers with concerns for the environment. So in order to demonstrate Category 3 customer status, with the NOI, you need to file current copies of the articles of incorporation or bylaws, or some similar legal document that establishes this authorization to represent residential customers before the Public Utilities Commission. And so and that gets a little bit tricky, which I'm going to talk about in the next couple of slides. But for now, I'll say that a Category 3 customer, in order to demonstrate significant financial hardship, basically needs to make a comparison between the cost of participation and the direct benefits to the members of the group, so that from the participation. And so, for instance, TURN might say, it's going to cost us $300,000 to participate in this proceeding, and if we're successful, we're likely to reduce customers' bills by $50 a year, and it's clear that the costs outweigh the benefits to the individual group members. And so the commission is looking for a comparison test like that. And when groups don't make that, then the commission will find the NOI deficient. So let's go to the next slide, please. Category 3 customer status can be tricky. I want you to know that some parties have struggled to establish Category 3 customer status because the PUC found their bylaws were deficient. And what the commission has said through its rulings that it is looking for is articles or bylaws containing provisions that directly or through a reasonable inference authorize a party to advocate on behalf of residential or small commercial utility ratepayers on the matters before the commission. And so in the next couple of pages, where I'm not going to talk you through all of them, but they are here for your resources, I have provided 4 examples of Category 3 customers with bylaws that the commission found insufficient, and they rejected the NOI. And I've given you some language in the commission's discussion about what was wrong with those bylaws. I've also given you a couple of examples of Category 3 customers that were successful. The commission found their bylaws sufficient, and I've picked 2 that were not like turn. It's all we do is do this before the commission, but a little bit different, so that you can see how the commission grappled with an organization that wasn't just so simply like turn, where kind of all we do is represent residential ratepayers at the commission. And those are there, and I'm going to say one more thing on the previous slide, but you don't have to go back to it. It's fine. I will just say it. So it can be a hurdle to establish customer status. And one of the things that compounds that challenge is that the commission is sometimes extremely slow to respond to an NOI that is filed. So you request a ruling on your NOI, and the commission is poised to issue a ruling determining whether you've established customer status and significant financial hardship. But sometimes months, years go by and there's no ruling. And that makes it very difficult to understand if you even have a chance of participating in the Intervenor Compensation Program, and knowing whether you might have a chance to apply for intervenor compensation one day can be critical for some parties to determining how much to participate. Do you hire an expert witness? Do you have, how many lawyers do you work with, if any? Kind of how do you staff the case? And so that can be very frustrating. And one of the things that you can do if you're in that situation, you filed an NOI, you're trying to figure out, is it going to work, is to contact the commission's intervenor compensation coordinator and or the office of the assigned commissioner for your proceeding to highlight your pending NOI and see if you can get a little bit more visibility and encourage a ruling to come out sooner than it otherwise might. Okay, so the next 3 slides, and you can just kind of click through them. These are small print, and I apologize, but there are 4 examples of bylaws the commission's found insufficient, and that's this slide and the next one. And then there are 2 examples that the commission found acceptable. And so these are really here for your resources. At the end, if we end up with extra time, I'm happy to go back and talk about these, but I really just wanted to give them to you. So let's go on to that one. Perfect. So this is potentially another hurdle. I don't know, but I want you to know about it, which is that state law expressly excludes certain kinds of entities from customer status for the Intervenor Compensation Program. And those are any state, federal, or local government agency, any publicly owned public utility, or an entity that, in the commission's opinion, was established or formed by a local government entity for the purpose of participating in a commission proceeding. So this was the statutory exclusion for a long time, and about a decade ago, the legislature created a carve-out for a local government entity that has experienced a catastrophic material loss of life suffered by its residents as a direct result of public utility infrastructure. And so this change was made after PG&E's transmission pipeline exploded under the city of San Bruno. And the city of San Bruno and San Carlos wanted very much to be involved in the commission's investigation and adoption of remedies for that explosion. And the legislature recognized that in that situation, a local government entity might not have the resources necessary to participate before the commission, and they made this carve out for customer status eligibility. So I wanted to let you all be aware of this because it may be helpful to explain in an NOI why the commission should not view a tribe as one of the expressly excluded government entities under California law for purposes of establishing customer status eligibility for intervenor compensation. And I list this as a tip because in my experience, if there's something that's maybe a little bit vague or it might be misconstrued, it is better to just put it out there and explain why it is not a problem, rather than sort of risk having staff at the commission grappling over this. Like, a tribe is a sovereign entity. Is it like a government, a state, federal, or local government agency, or is it not? And so you may want to actually just tee that up expressly and address it in the NOI. Next slide, please. Okay, this one I'm going to be super quick with. Once you've established significant financial hardship in one NOI, you don't have to do it every time. So there is a way to reference a previous successful finding of significant financial hardship. And that's, I think, all we need to say about that right now. All right, so the NOI, sort of the first hurdle is establishing that you're a customer that's eligible, establishing significant financial hardship. But then there's also this, what looks like a very detailed information that you need to provide. You need to tell the commission how you plan to participate and also estimate a budget for your participation. And there's a table in the NOI form where they want you to list the representative and how many hours they're going to spend and their hourly rate and how the dollars, and show how everything adds up. And they also want you to estimate how the total budget is going to be spread across the issues that you're planning to address. And this can seem quite daunting, particularly very early in a proceeding where you're still trying to even figure out, like, what are the issues going to be and how much are we going to participate and what are we going to focus on? It can be daunting. And so I want to just flag that this is a preliminary filing and the commission is not expecting it to be an accurate reflection of ultimately what's going to happen in the case, but it is an exercise that you do need to go through early on. And so you may say, at this early stage in the proceeding, we expect participating in workshops, filing comments, presenting expert testimony, etc. You just identify those things. And in terms of issues, if there's been a scoping memo already, which there often has not been by the time the NOI is due, you can talk about those issues that you're likely to address. But if that doesn't exist, you can just identify the issues based on what you anticipate that you will be interested in covering. So I have a tip here on this page about avoiding duplication, and that's because, as we'll talk about later on, one of the things that the commission closely scrutinizes in an actual claim for intervenor compensation is duplication with other parties. And so whenever I file an NOI, it's a good reminder to me to consider whether there are other parties in the proceeding that are likely to make similar recommendations, how we might talk and figure out how to avoid just flat out duplicating what each other is doing. And so so that is my suggestion early in the proceedings, so you don't end up 2 years down the road and you're like, oh, I wish we would have thought about this earlier. Next slide, please. So I mentioned that you have to include a budget estimate, and please try not to be daunted. Just understand it's really just a draft. It's based on what you know at the time. The estimates are non-binding. The commission, in my experience, will not evaluate the reasonableness of your estimates in your NOI, and they're also not going to hold you to those estimates in any way if you eventually file an intervenor compensation claim. In the claim, that's where you will need to justify the actual number of hours that you spent and the hourly rates requested for each of the party representatives. And the NOI form asks about costs, and you can put them in there if you have some, but currently the commission's intervenor compensation program does not pay for routine sort of office costs, overhead costs like postage or photocopying or online legal research subscriptions. It would really just be more extraordinary costs like long travel or I don't know, something else that might come up. Next slide, please. All right. We are going to now move into filing the intervenor compensation claim. And so let me actually ask Josh and Amy, do you prefer that I stop now and see if there are questions, or wait till the end and allow people to kind of sit with the information a bit more?
Oh, we can pause. I think I have questions that I can hold until the end, but does anybody have any questions about the NOI process they want to ask before we move into the claims? You can raise your hand, you can just unmute and speak. Well, hearing or seeing none, I say let's. Oh,
Sorry, I was drafting it in my mind here. I can go on camera. Thanks for the information. I guess one of the problems or one of the challenges we run into is like we don't know that the tribe wants to intervene until after the NOI period has closed. So can you comment on that?
Yeah, you know, someone else has mentioned that to me, and I know that that is actually um, not a unique problem. Sometimes you don't know till later. So that, you know, the rules are what they are. The commission's rules are what they are. And I will confess that that is one of the challenges that made me think there may be, it may be that there needs to be an exception to the rules, or a different process in some way. And so, you know, I think one, and I'm just totally brainstorming here. I mean, one possibility, um, yeah, I mean, I mentioned filing an NOI kind of almost as a placeholder, but you do need to have party status. So you would actually have to have the tribe that was willing to participate. I think, you know, the one thing I can say is that if you become a party, you file, you know, a motion for party status, or an initial set of comments or something that just kind of gets you in the door, and you file an NOI, you can still decide not to participate at all. That could be the end of your participation in a proceeding. That happens to turn sometimes. Like we check the initial boxes, and then we determine we simply don't have the resources to get involved, and that is it from us. And so I don't know if it would be feasible to work with tribes about some comfort with taking preliminary steps in order to keep the door open, and then to really do that more careful consideration of whether and to what extent to participate. And that's kind of, I'm working within the four corners of the commission's rules right now in offering that, which is there are a lot of constraints, so it's I'm not being that creative.
Okay, thank you.
So, I mean, have there been exceptions? Have they, like, does the CPUC, do the commissioners, or actually have the ability to make an exception to allow for an NOI to be accepted, you know, beyond those timeframes? I think you earlier said treat it as a hard and fast deadline.
Yeah. Yeah. The exceptions are so rare. I've seen them denied where a party is just deemed ineligible, and they've done all this work and it's just like, too bad for you. I've also seen, you know, and I have 25 plus years of experience. So if I can give you 2 or 3 exceptions, it means they're not occurring very often. And so that, you know, if a party was very new to the process and they weren't aware of the deadline, and the commission kind of made an exception, almost sort of a hardship exception. But they don't, in that case that I've seen, they didn't grant eligibility for the whole case. They said, well, from the point you filed, you know, wait, maybe we'll allow you to seek intervening compensation from that point going forward. I think the most meaningful opportunity to late file is when the commission changes the scope of the proceeding, or when a party brings in something totally different. And I'll give you a quick example of when that happened in a case that I was involved in. It was a PG&E application, and 9 months into the case, they amended their application to add a completely different program that was very expensive. And so there was a party that intervened at that point, and they said, hey, that's the issue we care about. And we had no idea that that was going to be part of this case. Commission, will you please let us file the NOI now, even though it's like 9 months after when, you know, everybody else filed it. And the commission said, okay, that's fair. So, you know, you can always file a motion, the way to request that things happen, a motion for permission to late file an NOI, and you'd probably need to describe what would be sort of extraordinary circumstances. And, you know, there was, you know, this timing of, you know, the council meeting at this time, and this was going on, and that was going on, and we weren't able to do it on time. And I have no idea if a judge would say okay, or if a judge would say no.
And I
But
can say as an ALJ running cases, I had situations where someone came in late and wanted to file an NOI after the deadline, for fairly sympathetic reasons. In fact, they were like a new participant. They weren't that familiar with commission proceedings. They just learned about an issue. And as the ALJ, I really wanted to let them in and be eligible. And I ran it up through ALJ management, and the answer was no. That's a statutory deadline. That's a hard deadline. So being sympathetic, being a new participant in general, is not going to get you the ability to file NOI late. This might be an area where there needs to be a statutory fix, because I think it actually, as an ALJ, to me, it felt like this really excludes a lot of entities and community groups from participating. The only ones who are participating are ones who are already familiar with PUC processes and aware of what's going on in a proceeding early on. And if you only figure out something months later, you're basically out of luck.
yeah, I agree, Peter. It's an area ripe for fixing. So, okay, we are starting the intervenor compensation claim process. So once again, deadline's very important. The major deadline is a statutory one, and it's 60 days after the issuance of a final decision closing the proceeding is the last day to file a request for intervenor compensation. You can file earlier. Some proceedings have many decisions. You could file after any interim decision that you believe you made a substantial contribution to. That's fine as well. But there is a cliff at the end of the proceeding. Next. All right. So the first thing you need to do is establish that you've made a substantial contribution to the proceeding. And it is not enough to just say, we said this, and the commission discussed it in its decision, because the commission often recounts what different parties recommend. But you actually have to link what you did in the case to outcomes that the commission adopted. And those can be facts that you asked the commission to recognize, or legal contentions, or policy recommendations, even procedural contentions. But you've got to do that linking. You need to cite to both your own pleadings, documents that were filed in the case, or your participation, and the commission's final decisions. And you've got to cite very specifically, like the page number in the document name, that sort of thing. And so the commission often will disallow compensation if they say you haven't demonstrated you made a substantial contribution, you haven't been clear enough. Just because we mentioned that you were there doesn't mean you made a substantial contribution. My suggestion is also that if you've made a recommendation that was successful, and another party made a similar recommendation, it's good to just be clear about that and acknowledge that you and another party or other parties all collectively made this substantial contribution, so the commission doesn't perceive that you're hiding the ball in some way. Next. I mentioned duplication at the NOI phase, which is always a reminder to me, you've got to avoid duplication. And that's because the commission can and does reduce awards if they find there's been duplicative participation with other parties. So sometimes they'll say, well, we're going to reduce your hours by 20% because there was duplication. There's some like significant cut that can happen. And that's because the commission is looking for interveners to show in a claim that their participation materially supplemented, complemented, or contributed to the presentation of another party with similar interests, or that the participation didn't overlap with what other interveners presented at all. And so that is something you're going to have to state in the intervenor compensation claim, how you avoided duplication. And so similar to what I mentioned before, a tip is that coordinating early on, if you anticipate other parties might have similar interests, talk about sort of who's going to do what, and maybe you explain your interest in different ways. But just anticipate that the commission's going to be screening for duplication. And also, if you do prepare joint comments with other parties, something TURN does quite a bit, it's important to be able to explain in the claim how we divided up the labor in order to create efficiencies, because that's what the commission is looking for. Next. So you also have to show the commission that your hours were reasonable and your costs were reasonable. And so the commission is specifically looking for a showing that your hours were productive, necessary, and needed for a fair determination of the proceeding. And they look for efficiency specifically. And so let me just, I'm mindful of time. There's more tips here about how to deal with reasonableness of hours, but I'm going to just skip on to the next slide, please. And you are, so in addition to talking about why your hours were reasonable, you are going to need to itemize all of your costs, every person, how many hours, including staff and external representatives if you have outside counsel or outside expert witnesses. And you're going to have to include timesheets for everyone who worked on the case. And the commission is very explicit about what those timesheets need to include. You need to identify for every task in chronological order the person who did the work, the date they did it, the issue in the case the task addressed, the description of the specific task, and the amount of time spent on the task. And the commission will closely scrutinize timesheets. And so it is important to know at the outset of her proceeding that the commission is expecting you to track time in this specific way, so that when it comes time to prepare a claim, you actually have the records in order to satisfy this requirement. Let's go on to the next slide. Some more information there you can go back to. Okay, so lots of tips. Actually, my tips page could be like 10 pages long, but we have a short amount of time today. So as I said, timesheets matter a lot. The commission will be looking for unreasonableness. The commission has disallowed compensation when an intervener combines hours for more than one task in a single timesheet entry. And the commission gives some examples of this, which I have here. The commission has penalized interveners for combining work on more than one issue in a timesheet entry. The commission has reduced awards for inefficiency if they think something took longer than it should. The commission has reduced awards for internal duplication if they think there are too many people working on the same thing and they don't understand why that is necessary or efficient. So it's good to talk about that in your claim. They have also, the program does not allow compensation for clerical or administrative tasks, and it's important that your timesheets explain what the person was doing with enough precision that it's not mistaken for a clerical or an administrative task. And it's also important to explain how the work was related to the party's substantial contribution, particularly where this might not be obvious based on the nature or timing of the activity. And so there are a lot of kinds of advocacy that can take place besides simply filing comments. And all of that advocacy may have all gone to support the outcome that you achieved, but you may have to do those linkages for the commission. And I want to just flag that it can take a very long time to prepare a thorough claim that tracks the commission's current guidelines. And Peter, it's been a long time since you've done this. It takes a really long time, and I want to flag that just so you start early.
Just to amplify one thing on the disallowances of various things, the initial screening of the intervenor comp request will be done by administrative staff in the ALJ division, but then it will also go to the assigned ALJ for the proceeding, who's familiar with the case to make a lot of the determination of substantial contribution, for example, and maybe looking at efficiency. The commission is not big on enforcing consistency. So different ALJs will be looking at things very differently. Some of them will be like, oh yeah, those guys did a good job. Boom, you're good. Others may be looking at it very closely. So just because one thing is awarded in one case doesn't mean it's going to be awarded in another case. If you got dinged in one case, you may not get dinged in another case. ALJ division is not good at maintaining uniformity of processes.
Thanks, Peter. Sometimes we call it whack-a-mole, sort of what it feels like. All right, we are almost at the end. I'm going to touch upon in the next slide a topic that has been the source of a lot of consternation for Intervenor Compensation Program participants in recent years. So the claim form itself and the commission's rules require you to request an hourly rate for each representative per year and provide the basis for the requested rate using the framework and requirements that the commission most recently updated in Resolution ALJ 393, starting with January, which took effect in 2001. And so the commission has on its webpage an hourly rate chart that you look to for guidance. And that chart has labor roles, nearly 80 of them, and provides hourly rate ranges per labor role by level of experience. And the ranges are fairly broad. The hourly rate chart does not tell you the rate to request for your representative. It gives you a range, and then you in your claim need to describe why this person's education and experience justifies the specific rate you're requesting, and you need to show it's in the range and how they match up with the hourly rate chart. So the commission requires when you request an hourly rate for a new representative that you need to provide their current resume and the other information that I just explained. So this is true for if it's a staff person, and as Peter noted, staff people we know don't actually get paid the hourly rates that that the organization requests in an intervenor comp request. But sometimes an intervenor hires outside counsel or outside expert consultants, and you have to provide the same information for those representatives. And the commission requires that the hourly rates you request for outside counsel or outside expert consultants must not exceed the rates they actually have charged for their services. And so if you go to the next page, I want to tell you two really important things that have happened recently. So past couple of years, the commission has required that when you submit a claim for intervenor compensation, if you're including time spent by outside service providers like counsel or consultants, the commission wants you to file with your claim an invoice or a retainer agreement showing the hourly rates that they charged for their services so the commission can make sure that the rate requested in the claim is the same. So this created quite a bit of challenge for a number of intervenors that have outside service providers working on contingency in order to make the services affordable. And so what the commission in recent decisions the recent decisions do suggest that the commission will accept contingency fee agreements as long as the party does not retain any of the intervenor compensation award tied to the outside service provider's work and instead passes awarded amounts through to the outside service provider. This is a very recent issue. It's just kind of, we're getting clarity around it in the past couple of months, but I wanted to pass that along to you. And so now we have our final slide. So you've been successful. You've established customer status, significant financial hardship. You made a substantial contribution to a commission decision. You filed that claim. You got through all of that. And now what happens? Well, in truth, you wait. State law does require the commission to issue a decision on intervenor compensation claims within 75 days of when you file the claim. But I must tell you, that is the exception, not the norm. The rare exception, you should expect significant delays in claim processing. And I've got a little bit of current statistics here for you. The commission on its intervenor compensation website maintains a list of all of the pending claims, and you can always see where yours is. Has it been assigned to staff? Has it not? And you can see how big the backlog is. And there are a lot of decisions now that have not been issued within 75 days. If, on the other hand, the decision comes out after that 75-day statutory deadline, then the commission will award interest in addition to the amount awarded. And I also just want to clarify that awards aren't paid necessarily they're not by the commission. They are paid by the utility that is the subject of the proceeding or from the commission's intervenor compensation fund. The commission's intervenor compensation fund is funded by jurisdictional entities that are regulated by the commission. And so because utility customers, so when it's a utility that on the energy side, I'll just point out, energy utilities pay for intervenor compensation award, and then they recover those costs from their ratepayers directly, dollar for dollar. And this is one of the many reasons why the commission tries to be very diligent in administering the intervenor compensation program, and that's because ratepayers are going to pay for the awards, and that's true on the energy utilities because they are rate regulated. So finally, once you get a decision, it comes out and it gives you an award, the claim must be paid within 30 days of the effective date of that decision. So finally, at the very end, it does happen pretty quickly. But as Peter noted, you may do the work and you may wait a long time for a decision, and then you may file your claim, and you may wait a long time for a decision on your intervenor compensation claim. This can be a long process. And as I noted at the beginning, there are a lot of hurdles and there's a lot of uncertainty. But at the end of the day, if you are able to successfully participate, it can really make a huge difference in being able to bring your wisdom and your recommendations to the commission. So thank you very much. Happy to take any questions now or follow-up questions if folks have questions later on.
We have a few minutes left. Does anybody want to share any questions or any experience with intervenor compensation?
I'll make a comment pending questions. So my firm M-Cubed has been a part of intervenor compensation for a lot of different groups, including the small business folks, farmers, Environmental Defense Fund. And a key question, and Turn is actually very adept at this, is how do you finance this effort, right? Like you're going to get compensation, maybe, but you have to potentially pay your experts up front. Maybe Hayley, a question to Hayley's comment on how Turn does that. But my experience is it's really one of three ways. The experts agree to get paid on the come, which is rare. The experts agree to get paid a discounted rate on the come, which we have done, or the client, the tribes in this case, pay upfront for the expert, and then the tribe is on the hook for making sure they get that compensation. Financing this effort, given all these uncertainties, is a critical thing that has to be addressed. And maybe Hayley, you can comment.
Yeah, I'd be happy to. Yes, this is a major challenge. And so I will tell you what Turn has done for decades and decades. So first of all, we were one of the original participants in the Intervenor Compensation Program. We were founded a decade before the program started, and so we have kind of been on this ride the whole time. That allows us to, we always have an award that's coming in funding prior work that allows us to have revenues to fund future work. So once you are established, that is helpful, but that is not the case for new entrants in the program. And this is one of the fundamental structural shortcomings in the Intervenor Compensation Program is there's no advance that would allow you to pay real costs. So what TURN does is that when we retain outside services, our basic retainer agreement structure has us pay a portion of the billed rate and defer the rest pending an award of intervenor compensation. So there's some cash we pay right away, and then there's a risk sharing for what happens with the intervenor compensation award. And we have found many experts over the years that have been willing to work on those terms, fortunately. But that's how we have done it. And if anyone wants to talk to me more offline, I'm happy to share, examples. We actually now have to file them with every compensation request, so you can see examples of our retainer agreements. But I'm happy to talk more about that.
Great. Yeah, thank you so much, Hayley. I don't think anybody wants to unmute and ask anything else or make any other comments. Very briefly, I will share that TECC, through our efforts on the self-generation incentive program, we there has been a proposed decision that was issued that is attempting to address the battery energy storage rebates. And we filed some comments, hopefully get that decision refined. And now we're in the period of reply comments to the response comments. And hopefully next time we'll have next meeting on more to report on the status of that, and hopefully the resolution, although it's taken a long time in coming to get here. And but really appreciate it, Hayley, and you sharing information on this topic. I think TECC is particularly interested. We want to support tribes in figuring out how to obtain intervenor compensation as well. And I think the tribal OIR may have a rescoping occurring, which I think may open the door